Hi, everybody, we're back. We had to set up a second stream. We did a YSL detour this morning. There was a hearing, so we started our day with watching that. Now, the big news of the day, in addition to TikTok being banned, there's so much legal news to catch up with, guys. TikTok, the Supreme Court upheld the ban. They have to sell. They cannot operate in the United States unless they sell. So that is one of the big pieces of news. But the other big piece of news has to do with President-elect Donald Trump. Now, you guys know that in Georgia, he was fighting a RICO case. There have been lots of things that Fani Willis has been up to this week. There's so much to catch up on. But one of the first things that we need to catch up on is this. It is the fact that she's suing the president. And let me show you this. We're just gonna go right on into the document and start reading it because there's a lot in there. And I found it to be super, super interesting. Let us share screen. Bam, here it is. And let me know if you guys can see and hear me by putting a 1 in the chat. That would be helpful. So Supreme Court, this was filed this morning, guys, like literally this morning, state of Georgia versus Donald Trump. And it sounds like you guys can see and hear me. So perfect. Thank you, guys. Thank you for verifying. Let's jump right on in because this is a very interesting document. Steve Sadow, Donald Trump's attorney, posted this and sent it to media people this morning. So this is going to the Georgia Supreme Court. Now, it is in response to one thing. Fani Willis this morning, or I think it was Monday, last month, she got taken off of the case. Her and her entire office are no longer allowed to be on this case, and that was the Georgia Court of Appeals. Now, she petitioned at the start of the week to be put back on the case. So on Monday, the 13th, she filed something, and she's just like, hey, I'm requesting that you guys put me on. Donald Trump is saying, no, keep her off. So this is Trump's response to that argument. And we're going to see what he comes up with. So this is an interlock appeal from the Superior Court of Fulton County. And this is the Honorable Scott McAfee presiding over the case. It went to the Georgia Court of Appeals opinion, and it was decided on December 19th, before the holidays. And he is saying reconsideration not requested. So this is the response opposing the state's petition for cert, right? So let's check it out. We've got a table of authorities. We've got reasons why we need to deny Fani's request. 1, cert must be denied because the petition fails to satisfy Rule 40, right? What is Rule 40? Rule 40A says no new standard was created. The majority applied for the Bloomingville's continuum of a rare significant appearance of impropriety based on the conduct of a public prosecutor. Rule 40C says this rare case is unlikely to reoccur, and Roman is not the appropriate vehicle to reconsider the appearance standard. So they're, you can already see that they're saying, hey, Fani, you can't particularly use this case as an example to talk about the standard for an appearance of impropriety. It's just not appropriate, right? Abuse of discretion. This narrow remedy opinion was based on the complete deference to undisputed trial court factual findings, dissent in error. Judge Land restricted the standard of review, misapplied precedent, and changed the facts to support his proposed absolute deference. It says the dissent would reduce the amount of the abuse of discretion standard to absolute deference. The dissent misconstrues precedent and conflates actual impropriety with the actual conflict of interest. And 3, the court did not reject the allegations of actual impropriety. Then he has a conclusion, and this was filed this morning. Let's go. We've got the table of authorities. So this is basically a list of cases. Usually with requests like this, you will see a long list of the cases that they're going to use. So we can skip over those pages. And let's look at the argument itself. President-elect, here we go. The Court of Appeals decision held that disqualification remedy fashioned by the trial court did not cure the significant appearance of impropriety caused by DA Willis's actual conduct. Let's highlight that, her actual conduct. And thus, the trial court abused its discretion by failing to disqualify her. That remedy holding by the Court of Appeals was both narrow and straightforward. The trial court's forced disqualification election, either DA Willis disqualifies her handpicked and former lover, romantic partner, Nathan Wade, or herself. And if you guys remember that, that is what Scott McAfee had to decide last year. He was a judge presiding over the case. His decision was either Nathan Wade goes or Fani Willis goes, right? It was an inadequate legal remedy under the circumstances of this rare case. So Trump and team and a lot of the other defendants were not satisfied with that decision that Scott McAfee made, so they appealed it. And they were successful in that appeal in some way because Fani Willis was ultimately disqualified from the case. The state's petition erroneously construes an opinion as the genesis of a new disqualification standard. Oh, okay. For prosecutors and an uphill standard of review. The Court of Appeals opinion did no such thing. Okay, that's why Fani Willis was asking for it, because really her stance is we need to talk about the disqualification standard. She believes that she should not be disqualified from this case. And she's trying to tell the court the reasons why, right? And they want to look at the standard of, what is the baseline? What is the rule when we remove prosecutors or a prosecution office off of a case? In this case, it was a DA's office. Everybody from her office got removed, right? Let's keep going. The Court of Opinions did no such thing. Cert generally will not be granted merely to correct an asserted error, particularly when the asserted error concerns only the application of a properly stated rule of law to facts of a particular case. Contrary to the state's petition, the Court of Appeals did not misapply Blumenfield, the standard for the appearance of impropriety, when it held that the undisputed factual findings as to DA Willis's conduct-based actual impropriety mandated disqualification. So they're trying to say here that, based off of their factual findings, it was based off of her conduct and it warranted disqualification. Roman correctly noted that an appearance of impropriety may disqualify a prosecutor, and that Willis's rare specific conduct moved this particular case from the middle of the continuum to that portion where the disqualification is mandated, because it is the only remedy that could purge the taint of impropriety. The state's petition is incorrect. So they're saying, hey, the document that Fani filed earlier this week where she wants to stay on, her petition is incorrect, as the Court of Appeals did not need to define rare, for the factual circumstances underlying this case are simply unprecedented. This case is not incongruent with Rule 40, and this rare conduct and significant appearance of impropriety is not likely to reoccur, because no Georgia district attorney has engaged in this level of unprofessional conduct before. Woo! Trump coming in hot. It is highly unlikely that any DA will ever do so in the future, and no Georgia court has ever been faced with such actual impropriety by a Georgia DA. Ooh, this is heating up, guys. He is basically saying, no DA in the history of Georgia has ever acted this way or had conduct like this, right? But Fani, you did. Without likelihood to reoccur, Roman is unlikely to set precedent that will illuminate future cases, and it is not an appropriate vehicle to squarely reconsider the appearance of impropriety standard. Cases cited by the petition authorize both the trial court and the Court of Appeals to disqualify Willis based on a significant appearance of impropriety in light of and considered together with Willis's actual specific conduct. Contrary to the petition and a correct application of this abuse of discretion review standard, the majority gave the legally appropriate deference to the trial court's findings of impropriety, which were not cross-appealed. Upon doing so, the majority found that the outright disqualification of Willis was mandated by the significant appearance of impropriety. The odor of mendacity that remained over this prosecution even after the trial court's remedy for forced disqualification of either Willis or Wade. So one of them had to go. Moreover, the state's adoption of the wholesale reliance on the dissenting opinion collapses under its own weight. This dissent's three fatal errors. And when we talk about the dissent, I read that opinion to you guys. So when the Supreme Court, the Court of Appeals, when they made their decision, there was a group of judges that made that decision. One of them dissented. The rest of them agreed, right? So they're looking at the dissenting part, and I had not had a chance to look at Fani's findings or her document, but I can tell that that was partly included in her document because it seems like it's a part of her argument. She's utilizing some of the things that were mentioned in the dissent, because in the dissent, that dissenting judge didn't feel that Fani Willis should have been removed from the case. So only one judge out of the body of judges that wrote the opinion agreed that she should stay on. The dissent's three fatal errors, to wit, restricting the standard of review, misapplication of precedent, and incorrect understanding of the trial court's findings, fail to show a compelling case for cert, and in fact, they support the majority decision. Because the questions presented involve routine applications of settled law to undisputed facts, cert should be denied. So Trump is saying, please deny her request. And here are the questions and reasons why. President Trump requests that this court deny the state's petition for cert and thereby affirm the Court of Appeals opinion as the law of this case. Correctly framed, the questions are, should this court deny discretionary review of the Court of Appeals holding by the application of the continuum standard to DA Willis's conduct mandated the remedy of her disqualification in this unique fact-specific case where the trial court found a significant appearance of impropriety based on undisputed factual findings? That is a long-ass question. Let's go to our second long-ass question. Should the court deny discretionary review of the Court of Appeals application of the abuse of discretion reviewing the standard because it properly stated and employed this rule of law to the undisputed facts of this particular case in holding that the trial court erred, meaning that they made an error in failing to disqualify DA Willis? Two long-ass questions. Reasons to deny the request. Reason one, cert must be denied because the petition fails to satisfy Rule 41. Review on cert is not a right. Under Georgia law, a petition for the writ will be granted only in cases of great concern, gravity, or importance to the public. Great concern, gravity, or importance to the public is not defined, yet cases suggest this phrase is typically reserved for issues of first impression, meaning the first time you see it, for which an establishment of the precedent is desirable, not the application of settled rules to unique, undisputed facts that are extremely unlikely ever to reoccur. Even where an issue is of first impression, cert is routinely denied for the wrong vehicle. All right. Disqualification of a public prosecutor for the appearance of impropriety is not an issue of first impression. The majority cited battle to apply Bloomingfield continuum to specific conduct that created the significant appearance of impropriety, because the Court of Appeals described DA Willis's conduct as the rare case to mandate disqualification. The petition presents an application of a properly stated rule of law to facts for which cert will not be granted. As former Chief Justice Nemes wrote, the court has emphasized a high standard for granting cert review since its very first case in exercising authority. We're going to skip over that. The state's petition has squarely failed to meet that standard. Applying this background for cert together with Rule 40's non-exclusive examples, cert should be denied for 4 reasons. All right, reason number 1. First, the majority faithfully applied the Bloomingfield's continuum standard for disqualification based on an appearance of impropriety. Second, this rare, indeed unprecedented factual scenario is unlikely to reoccur, and a significant appearance of impropriety based on conduct is legal basis to disqualify. Third, this remedy opinion, driven by complete apparent deference to the trial court's undisputed findings of impropriety, correctly applied the abuse of discretion standard of review. And finally, The dissent erred in restricting the abuse of discretion standard of review and by misconstruing the uncontested facts, the majority analysis, and existing precedent to support its newly proposed bright line rule of absolute deference. So there's a lot of talk about Rule 40 that says that no new standard was created. The majority applied the Bloomingfield's continuum. They did that correctly, according to Trump here. There was no deviation from these cases. The phrase per se appears not once in the majority analysis. The petition is wrong. Roman did not usurp this court's authority or create a per se disqualification standard for an elected district attorney. Instead, the majority faithfully applied Bloomingfield because the second guiding principle noted by divisions of the first paragraph was that the attorney's disqualification is viewed as a continuum. As opposed per se rule for prosecutors, the majority made clear that it was the rare facts of this case. Notice that they're putting that in quotes a lot. This case coupled with the trial court's finding of a significant appearance of impropriety, which rendered its otherwise diluted remedy wholly ineffective. All right, this is text from that Bloomingfield case. This block quotation from Bloomingfield's continuum was the heart of Roman's Division 1 analysis. The majority applied Bloomingfield's continuum, citing D.A. Willis's role as a public prosecutor as one factor, among others discussed below, to move the remedy from the middle to the top of the continuum for disqualification. After carefully considering the trial court's findings, disqualification was mandated by undisputed facts that the appearance was significant, right? And impacted more than mere nebulous public interest. Okay, so that's interesting. That the odor of mendacity remained even after the trial court's remedy. From the world's observation of D.A. Willis's seemingly untruthful testimony. So yeah, Trump's not letting that go. He's just like, she was lying. Concerning her relationship with Sada Wade. So Mr. Wade. They are definitely highlighting the fact that they think that they lied here. Specifically, the majority moved the remedy up the continuum based on the following undisputed trial court findings to D.A. Willis's conduct. The following facts were not cross-appealed. This appearance of impropriety was significant. It was more than a nebulous public interest was impacted. Chief Judge Birney disqualified Willis during the special grand jury proceeding for naming Lieutenant Jones a target after hosting a fundraiser for Jones' opposition candidate. D.A. Willis continued to supervise and pay Wade during their romantic relationship. Substantial taxpayer funds paid Wade. Oh, let me read that again. Sorry, guys. Substantial taxpayer funds paid to Willis's lover, Wade, were used by her for trips and vacations with him without verifiable reconciliation of funds she claimed were reimbursed. This is the whole thing about cash when they went on vacations and things, right? She paid for things using cash, but cash is, you can't really trace that. So it's interesting. Willis testified that Roman's motion to disqualify her only cemented her relationship with Wade. Wade's inaccurate interrogatory responses indicated a willingness to wrongfully conceal his relationship with Willis. Both Willis and Wade gave potentially untruthful testimony under oath at the disqualification hearing. That's a big deal. An odor of mendacity remained over the proceedings. Taken together, according to the trial court, an outsider could reasonably think that the district attorney is not exercising her independent professional judgment totally free of any compromising influences. Nonetheless, the state incorrectly argues that the majority opinion failed to apply Bloomingfield. To support this faulty premise, the state distorts and misconstrues the majority's statement that these undisputed factors took this case out of the continuum of cases involving an appearance of impropriety in connection with the conduct of private counsel and client's interest in counsel of choice balanced against a more nebulous public interest. But the state's argument is nothing more than a contrived misunderstanding of what this language actually did. Takes out, did not discard the continuum. takes out applied to the continuum is the rare facts found by the trial court as significant appearance of impropriety found by the trial court. So they're looking at language like that includes the words takes out. So that must mean that Fani was probably leaning on that from this Blumenfeld opinion, explaining that the case applied the continuum in a motion to disqualify private counsel where the important interest in the right to choice of counsel must be balanced and only a nebulous interest in the public at large in the propriety of the bar. Also, not so here. Here, the public's interest and defendant's interest in a disinterested prosecutor are aligned. When applying the continuum, these distinctions demanded disqualification because it was undisputed that the public interest impacted by this significant appearance of impropriety was more than nebulous. Consistent with Young, Roman underscored the important public interest at stake given the district attorney's role as an administrator of justice. As the majority noted, the responsibility of a public prosecutor differs from that of a usual advocate. And the district attorney has additional professional responsibilities as a public prosecutor to make decisions in the public's interest rather than balancing a defendant's constitutional right to choice of counsel against the nebulous public interest in the propriety of the bar. This case involved the important public interest in having a disinterested prosecutor in addition to the defendant's right to one. So that's the thing. When Fani Willis needs to be disinterested from a case, it's not about, going after Trump or whatever the case may be. You have to have a disinterested stance, right? Like you're supposed to be a public servant. You're seeking justice for actual crimes, not, pursuing somebody for political means or whatever the case may be. Or the fact that you're taking taxpayer funds and you're paying your lover as you guys are prosecuting a president. The majority's continuum application did not create a new per se standard for the prosecutor. That application involved the public prosecutor was one aggravating fact that moved this case along the continuum and out of the cases dealing with private practitioners. A client's choice of counsel in the nebulous public interest of the propriety of the bar. Having already moved along the continuum, the majority found the significant appearance of impropriety based on Willis's rare and specific conduct. He uses the words rare and specific a lot. It is rare. It's not every day where you see, a married man and a district attorney work together, and they're working on one of the most important cases in Georgia history. Right? It's a RICO case against a former president and now, a elected president, right? Notice that this document was filed today, and according to you guys, the inauguration is scheduled for Monday. So it is very clear that Trump's not letting this go, and neither is Fani. Fani filed this, request to have the Supreme Court in Georgia overturn the decision. She did that this past Monday. And Trump is saying, you know what, we're going to wait until Friday. We're going to file it. And the answer should be no. So this is more of a persuasive argument. I don't believe we're going to get a decision on this fairly soon, maybe in the next few weeks, but maybe not next week. Right. So super interesting. They moved the case to the mandatory disqualification portion of the continuum because no other remedy will suffice to restore public confidence in the integrity of the proceedings, which is right. That's actually super persuasive. No bright line rule of per se disqualification for prosecutors was created by the majority opinion. Indeed, had each of the rare circumstances in this particular case not been present, to wit, significant appearance of impropriety, disqualification from special grand jury, campaign finance violations, covert romantic relationships with Mr. Wade while under contract funded by taxpayer dollars, persistent concealment of the relationship, and the odor of mendacity from potentially untruthful testimony. Disqualification might not have been required. The majority correctly considered each factor in the factual context as a whole. So Trump's team is saying, and Mr. Stadow, who's likely wrote this, is saying that, hey, the majority opinion is correct. They went through the proper factors as far as their decision to disqualify, and we should not disturb their decision. Fani's post-conviction citations, and she cited two cases, a 2005 case and a 1999 case, are poor benchmarks for the majority opinion, which distinguish Whitworth in the footnote, given the posture of the Roman defendants who are presumptively innocent. Neither case cited Blumenfeld nor mentioned the continuum, despite publication long after 1981. Most importantly, the alleged appearances there were not based on specific and actual conduct. So this is where Steve Sadow gets a little granular with the cases that she's used, because he's like, okay, if you want to challenge them, that's fine. But you're looking at the Blumenfeld standard, right, of what happens when there is an appearance of impropriety. Well, if there's an appearance of impropriety, what you have to look at is the conduct of the prosecutor that's involved. What did they do that would lead for them to be disqualified from the case, right? A fundamental flaw in Fani's red herring argument is the supposition that disqualification was based on Willis's status, i.e. a public prosecutor. Not so. Both the trial court order and the majority opinion emphasized that this significant appearance of impropriety was based on her conduct. With undisputed findings of specific conduct at the center of the analysis, the state's apprehension of per se rule for prosecutors is unfounded. Roman's holding is not that a mere appearance of impropriety involving a public prosecutor requires disqualification in all cases, but that disqualification of a public prosecutor was mandated in this case by the rare and undisputed facts that the significant appearance of impropriety found by the trial court. Though the petition protests that the majority was conclusory and failed to explain its analysis, it's this myopic focus on Division I's concluding paragraph is willfully blind to the incorporation of 15 paragraphs of the trial court's findings in its order. Wow. The answer to how the majority applied these separate considerations to reach disqualification is simple. Additional and rare aggravating factors demanded it. Accordingly, because Roman merely applied Blumenfeld's continuum to rare undisputed factual findings of specific conduct involved a public prosecutor, this petition involves only the application of a properly stated rule to the facts of a particular case. Cert should therefore be denied. So notice that this gets very technical. They're really pulling apart Fani's argument, the cases that she's using, challenging, these folks, saying that they are wrong for taking her off of the case, and that they inaccurately applied the law. They inaccurately did not include the right standard and things of the like. And she says, you should look at this, Supreme Court. You should put me back on. I was unfairly taken off of this case. She's not letting it go. Not letting it go. Going to check out some super chats. Shout out to Stanton with the 2, says Fani needs to be held accountable. I agree. I think she should. In Georgia, when you're a prosecutor, you are in any state in the United States, it's a pretty serious job. Not even just prosecuting cases. When you're the district attorney, you're one of the most senior law enforcement officers or people that are attorneys in the state. And it's really important that you hold yourself to a high standard. But if there's something like this happening, it doesn't look good. And then in addition to that, taxpayer dollars are being spent inappropriately, right? So interesting stuff. Shout out to Deonra with the 2, says Fani, Fulton County, Willis. Yeah, I mean, she's staying on top of this. She does not want to let go of this case. And shout out to Charlie, who's right. They are highlighting her misconduct. And they're, Trump in this argument is really highlighting the fact that both her and Nathan Wade lied on the stand. He said that a few times in this document so far, a few times. So thank you so much for pointing that out, Charlie. Let's keep going. So they're looking at Rule 40. This rare case is unlikely to reoccur, and Roman is not the appropriate vehicle to reconsider the appearance standard. So although Fani wants to be put back on the case, the other thing is they're looking at the standard of review. You know, what's the rule when we want to take a prosecutor off or a district attorney's office off of a case? What Trump's team is saying here is that you shouldn't be using this case to revise that, Fani. If you want to go and look at what the standard is, that is what the law is in the state of Georgia, right? If it needs to be changed, there are other ways to do that, but don't use this case to change the law. The Court of Appeals did not need to define rare. The majority's express finding that Roman was the rare case in which disqualification is mandated and no other remedy will suffice to restore public confidence. They're looking against cert for a second reason. This question of Georgia law is not likely to recur. Mandatory disqualification of an elected district attorney for a significant appearance of impropriety for specific conduct is unlikely to recur because no Georgia district attorney has engaged in such egregious disqualifying conduct before. And it is highly unlikely that any DA will ever do so in the future. No Georgia court has ever considered impropriety of this extraordinary magnitude. So what they're saying here is like what Fani did is not normal. Nobody's ever done it before. And we don't see anybody doing it in the future. No Georgia court has ever considered impropriety to this extraordinary magnitude. So they're really coming at her neck here. Like they're highlighting it. Like no other DA has done this before. We've never seen it before. And the court system has never had to litigate something like this before. With no likelihood of reoccurrence, Roman did not create a novel precedent, like a new one, but merely establishes the law of this case. Rare facts and no likelihood of reoccurrence make Roman an inappropriate cert vehicle to squarely reconsider the appearance of impropriety legal standard for disqualification, though it describes the appearance standard as a relic of the former code of professional responsibility. This petition does not seek cert on this ground. The state cannot have it both ways. So Fani, you can't have it two ways. It prefers a variable, non-mechanical legal standard, but not so variable as to be materially affected by significant and rare aggravating factors. The petition maintains that the application of the appearance of impropriety standard alone to authorize disqualification is not accepted practice in Georgia. This is another red herring. This standard was not applied alone. The state's argument ignores the findings of actual impropriety that predominate the trial court's order. Cases cited by the state in its own petition interpret Blumenfeld to authorize disqualification based on the appearance of impropriety in conjunction with actual impropriety. Let's see where we pick this up. Okay, this is talking about the Supreme Court. Cohen and G.A. Trails disjunctively distinguish actual impropriety from an actual conflict of interest, and the majority here relied on indisputed litany of actual impropriety from the trial court's order. So there's a difference between actual impropriety and a conflict of interest. In sum, because this rare case is not likely to recur or provide significant precedential guidance beyond its unique facts, cert should be denied. All right, now let's talk about abuse of discretion, because she is likely arguing that the Court of Appeals abused its discretion. This narrowly remedy opinion was based on complete deference to undisputed trial court factual findings. From the outset, the majority narrowed the scope of its holding to the adequacy of the trial court's remedy. Division 1 found an abuse of discretion based entirely on facts found by the trial court, and because of the court's findings in the failure to impose a remedy adequate to cure the ongoing problems its order identified. Here, the state's ironic complaints that the majority did not dispute any of the trial court's factual findings supports a proper application of the standard of a review and a denial of cert. The petition echoes the dissent. She does. I knew she did that. So she is siding with the only person that agreed that she should not be taken off the case. The only judge in that decision. She brings up the dissent. So let's see how the Trump team talks about this. The petition echoes the dissent, arguing the majority failed to apply the abuse of discretion standard and substituted its own discretion. So Fani is saying the majority didn't apply the right standard and they substituted it with its own. Nothing could be further from the truth. By expressly incorporating 15 paragraphs from the trial court's order, the majority gave complete deference to the trial court's finding, noting 3 times the state did not cross-appeal the finding of significant appearance of impropriety. The majority did not find its own facts. It block quoted factual findings set out in the trial court's order. That's right. And I know this, guys, because I read it to you. We read it together. We can actually link it to this video if you want to see it. In that decision, they walked thoroughly through Scott McAfee's decision and they placed it in there. So it was like, okay, let's take a paragraph. This is what he said. Let's analyze that further. And we're responding to it, or we're adding our opinion in it. It's in the analysis portion. So much of legal writing, especially when you're looking at an opinion that is very different from yours as a writer, you need to make sure that it is compelling, but you're also using what the factual basis or whatever the conclusions are from the other side or whatever you're analyzing. You have to include that before you respond. So if there were 15 paragraphs that they included, that is interesting that she's saying that what they did was wrong. It block quoted factual findings set out in the trial court's order. Fani's argument that the majority found no legal error overlooks language within the same expert that it quotes. The trial court's remedy did not redress problems it found were still there. Although the standard of review is differential, it's not toothless, and abuse of discretion occurs where a ruling is unsupported by any evidence of record or where the ruling misstates or misapplies the relevant law. All right, so this is Steve Sadow grabbing something from the document itself. Let's just read that. It says, after carefully considering the trial court's finding in its order, we conclude that that Scott McAfee made an error by failing to disqualify DA Willis in her office. The remedy crafted by the trial court to prevent an ongoing appearance of impropriety did nothing to address the appearance of impropriety that existed at times when DA Willis was exercising her broad pretrial discretion about who to prosecute and what charges to bring. While we recognize that an appearance of impropriety generally is not enough to support disqualification, this is the rare case in which disqualification is mandated, and no other remedy will suffice to restore public confidence in the integrity of those proceedings. That comes directly from the decision, you guys. Directly from the decision. Interesting. As the majority explained, the trial court forced election of Willis or Wade did not purge the taint from the pre-indictment stage, and it was insufficient to cleanse future proceedings of the odor of mendacity that the court found remained. So they're saying right here, the majority explained that. So if Scott McAfee is saying, Judge McAfee is saying, hey, either you have to get off of the case, Fani, or Nathan Wade has to get off of the case. That didn't solve anything. It didn't go far enough. So the Supreme Court is saying because it didn't go far enough, we are now taking her and her office off as well, right? So even though that happened, Scott McAfee's, not mistake rather, but just the fact that it didn't solve anything, the odor of mendacity was still there. It was still there. Given the findings of significant and actual impropriety and the remaining odor of mendacity, the majority rightly concluded that the trial court's inadequate remedy was outside the range in which responsible jurists could disagree. Because disqualification was the only remedy legally adequate to purge the ongoing significant appearance of impropriety, the majority correctly held that the trial court's exercise of discretion was infected by a significant legal error. By finding significant error in remedy, the majority correctly applied the abuse of discretion standard, and cert should be denied. Dissent in error. Judge Land, this is the dissenting judge, restricted the standards of review, misapplied precedent, and changed facts to support his proposed absolute deference. The final erroneous pillar of the state's petition is its adoption of the dissent's flawed reasoning. So, okay, Steve said I was about to go in. So he's now telling us that, Fani, you are relying on the dissent in that opinion. Let us now tell you why the dissent is wrong. Let's talk about that. Okay. The dissent incorrectly took exception to the majority's reversal, advocating for absolute deference to the trial court's remedy. The dissent's position was simply wrong. Respectfully, the dissent suffers from three analytical flaws. Let's start with the first one. First, the dissent restricts the abuse of discretion standard to a mechanical bright line rule of absolute deference. Second, the dissent misconstrues precedent, conflating actual impropriety with an actual conflict of interest, which is actually kind of sad that a judge did that. Finally, the dissent is based on a misunderstanding of the facts found by the trial court. So they are saying that this judge did three things, or at least had three flaws in their reasoning. The first one is a standard to a mechanical bright line rule of absolute deference. So that's the first one. Second is that they got confused with actual impropriety and a conflict of interest, which is two different things. Lastly, the dissent is based on a misunderstanding of facts by the trial court. So let's break all three of those down. First, the dissent would reduce the abuse of discretion standard to absolute deference. The dissent begins with general language misconstruing the standard of review. Imported, did that just skip something? Imported from, a Ventura case. Neither Ventura nor Newman describes the contours of this standard, nor mention the appellate court's authority to reverse cases of significant legal error. Because precedent from this court does, in fact, vest the Court of Appeals with authority to reverse despite the appropriate defense, the dissent's framing of the standard is at best incomplete. This court has written, such discretion is not unfettered. The trial court must exercise its discretion with conformity with the governing legal principles and the facts that the court is to find, and those which must be evaluated by the court are those relevant to determining whether the legal requirements have been satisfied. Actually, this is coming from a 2014 case, so I'm not going to read that, guys. The dissent does not engage in the majority's authority to reverse, nor does the dissent explain how the trial court's remedy was adequate to cure the ongoing problems with the trial court, which the trial court identified. The dissent undertook no remedy analysis. In the dissent's view, absolute deference to the remedy fashioned by the trial court was required by the mere fact that no actual conflict of interest was found. Here, although it notes Blumenfeld's rejection of a per se rule for a disqualification, it was the dissent that advocated for a mechanical per se application of a continuum. The dissent sweepingly that a trial court's remedy is not within the scope of appellate review. This is a quote from the dissent. It says, "I am particularly troubled by the fact that the majority has taken what has long been a discretionary decision for the trial court to make and converted it to something else in its entirety." It's another quote from the dissent. When, as here, a prosecutor has no actual conflict of interest and the trial court, based on the evidence presented to it, rejects the allegations of actual impropriety, we have no authority to reverse the trial court's denial of a motion to disqualify. None. So this dissenting judge said that we cannot change Scott McAfee's decision. Though it discusses Blumenfeld generally, Blumenfeld's generally, the dissent's view of the abuse of discretion standard would actually prohibit an appellate court from auditing a trial court's remedy determination as required from the Blumenfeld continuum. This would improperly render a trial court's application of Blumenfeld's factors so long as actual conflict was not found below. That dissent argument was predicated on the flawed assumption that no factors other than actual conflict can move the remedy within the continuum to disqualification. Blumenfeld did not so hold. On the contrary, Blumenfeld described the appearance of impropriety based on conduct on the part of the attorney, generally as only type of appearance that was not anchored along the continuum at the ends of the spectrum where disqualification decisions were mandated. Because an appearance based on conduct was not anchored, but instead was somewhere in the middle, fact-specific circumstances dictate whether disqualification is necessary. Blumenfeld explained that an appearance based on the conduct was generally insufficient to outweigh the client's interest in counsel of choice based on three factors that the trial court found were not present here. Looks like those three factors were a nebulous of public interest, the absence of danger to the client, and the client's interest in counsel of choice. Those factors strongly support the disqualification remedy in this rare case. The public interest in a disinterested prosecutor was not nebulous. The appearance was significant, causing danger to the defendants, and the only choice of counsel interest was the defendant's interest not to continue with a tainted prosecution. That's it. Absolute deference without regard to the Blumenfeld's factors usurps the appellate's authority to review the trial court's analysis of the continuum based on the facts it found. This is not Georgia law. Reason number two, the dissent misconstrued precedent and conflates the actual impropriety with actual conflict of interest. I can see that happening here. Beyond restricting the standard of review, the dissent objects that this Williams case did not discuss disqualification based on mere appearances. Published after 1981, Williams did not cite Blumenfeld nor discuss the appearance of impropriety precisely because that disqualification challenge was not based on appearance and instead was based on forensic misconduct, though that prosecutor's violation of the rules of professional conduct. Though the dissent was correct that Williams is the leading criminal case dealing with disqualification of prosecutors, it was dead wrong to import Williams' analysis of a forensic misconduct argument into the appearance of impropriety context. There it is, guys. That's the bombshell. Heavy reliance on Whitworth, not precedent below, failed to show the majority's incongruence with a decision of this court. The dissent did not respond to the majority's distinction in footnote 4. The dissent's attempt to finesse an otherwise inopposite near summary decision also falls flat. Tellingly, the dissent did not cite Lee's Division 5 analysis, only one sentence in the introduction. Contrary to the dissent, no principles were reiterated. The dissent's confusing footnote 3, shout out to Steve Sadow, the majority, consistent with Battle, the majority applied Blumenfeld to a prosecutor and described its remedy as extraordinary. Finally, the dissent's analysis of cases applying the appearance of impropriety standard actually supported the majority's decision to reverse the remedy. Think about that. Sometimes it can be confusing. And this judge actually cited some cases or made some arguments that actually supported the majority, even though they were dissenting. Looking at two cases here, we're seeing Henson and Georgia Trails both expressly authorize disqualification for an appearance of impropriety based on actual impropriety, though it twice protests that the trial court rejected allegations of actual impropriety. The order shows otherwise. A fatal flaw in the dissent's argument is its assumption that actual conflict of interest and actual impropriety are synonymous. They are not. That's right, guys. They're two different things. An actual impropriety refers to the conduct on the part of an attorney that creates the appearance of impropriety, as opposed to mere status alone. Cases use these terms disjunctively, indicating that either an actual conflict or an actual impropriety coupled with an appearance is sufficient to disqualify. Because the trial court did, in fact, find actual impropriety, and the cited cases authorized disqualification on this basis, the dissent provides no grounds for cert. So that's huge. The dissent provides no grounds for cert. So why did Fani use it in her argument? The trial court did not reject the allegations of actual impropriety. A flawed premise central to the dissent's analysis is the factual claim that the trial court rejected allegations of actual impropriety. It did not. McAfee rejected an actual conflict of interest, but in his order, in several locations, found several instances of actual impropriety based on D.A. Willis's conduct. Specifically, the order noted D.A. Willis's disqualification during the special grand jury investigation, her unprofessional and potentially untruthful testimony concerning her clandestine relationship with Special Prosecutor Nathan Wade, her failure to keep any form of verifiable reconciliation for her cash with transactions with Wade, her campaign finance violations, her efforts with Wade to hide their relationship through false affidavits, interrogatory responses, her racially charged speech before a historically Black church on Martin Luther King Day, and the potentially dishonest and untruthful in-court testimony of Prosecutor Nathan Wade and D.A. Willis, characterized as an odor of mendacity by the trial court. Contrary to the dissent's characterization, the trial court's remarks categorizing Willis's conduct and testimony as a tremendous lapse in judgment, unprofessional, and potentially untruthful. Oh, Steve is cooking here. This is interesting because Judge McAfee did say that. He said all those things. Those are undisputed facts. Contrary to the dissent's characterization, the court's remarks characterizing Willis's conduct and testimony as a tremendous lapse in judgment, unprofessional, and potentially untruthful on the specific conduct did not merely chastise Willis, they found impropriety. These findings were so impactful that the trial court noted that this perceived conflict in reasonable eyes of the public threatens confidence in the legal system itself, and these findings were not cross-appealed. The dissent wrote, for the last 43 years, our appellate courts have held the appearance of impropriety without actual conflict of interest or actual impropriety provides no basis for the reversal of the trial court's motion to disqualify. But unlike those prior cases, this rare case did involve findings of actual impropriety, making it both an outlier and extraordinary, even under the dissent's view. For that reason, and as explained in the opinion, the majority's disqualification remedy was the only legally adequate remedy. Conclusion: for the foregoing reasons, President Donald J. Trump respectfully requests this court deny the state of Georgia's petition, the writ, and thereby affirm the Court of Appeals opinion as the law of this case. Respectfully submitted today, this morning, guys, Steve Sadow, Jennifer Little, and Matt Winchester, all counsel for President Trump. So interesting timing, right? Interesting timing of this to come out today, the weekend before the inauguration. I found that on, came across my desk this morning. Somebody had emailed me that document. I was just like, wow, interesting timing, right? Now, I had my eye on this all week because there is more. There are more updates, but I'm going to take a quick little break before we give you those updates. Shout out to, there goes Stacy with the 20. Thank you so much, Stacy. She says, thank you for keeping information and all of us informed. Because of you, I started my channel a few months ago. There goes, look at you, Stacy. Great job. Congratulations on starting your YouTube channel. It is a fun journey. I actually just got assigned a YouTube manager from YouTube itself, so I will be chatting with them later today, but it takes time to build, so be patient with yourself, and I'm sure you're gonna do fantastic. And if any of the mods are hanging around, you got a link, we could check out your channel, Stacy. Thank you so much. Shout out to E Capone with the 5, says felon should not be president. Yeah, I saw a funny meme this morning. It was, I think it was Cat Williams, and he was talking to somebody, and he was just like talking about, yeah, I had all these felonies, but I didn't go to jail. And they were talking about Trump with it. It was kind of crazy. But thank you so much, E Capone. Really appreciate the $5 super chat. So if you thought that was all Fani Willis was up to this week, you are wrong. So she started the week with filing this, writ of cert to the Georgia Supreme Court so they could put her back on the case. She really wanted to be put back on the case. Then she got ordered, I think this was Judge McBurney last week. It wasn't this week. It was last week. She was ordered to pay Judicial Watch like $22,000 because of the stuff that's happening with open records, right? Ashley Merchant was on the channel. We have been talking about that for a few weeks now. So we have that. There's more. Fani continued after threatening, or actually there is a threat to sue somebody else. I'm going to show you guys that too. After that happened, she came out and started speaking about the Georgia prison system. Like, you guys know that the Georgia prisons are not in the best shape. Let's watch this short excerpt here.
Our mayor is so polite. He's such a Southern gentleman, right? Fulton County leadership, we need the Fulton County Commission to do their job. The reality is the sheriff cannot do his job, nor the district attorney hers, if it is not financed properly. We have known for years, and the sheriff has been begging for years. The jail is falling apart. The prisoners are using pieces of the jail to make shanks to hurt other prisoners. We know that. Atlanta has done their part. They gave us a facility. They've helped us in the way that they can. This is not on the mayor's shoulders. It's not on Atlanta Police Department shoulders. It sits on Commissioner Rob Pitt's shoulders. And we ought to demand that they have humane conditions. We ought to demand that the DA's office is financed in a way where we can properly prosecute crimes. And citizens ought to call and say, we don't want people to live in these inhumane conditions. And he gave it to you lightly. I've been a district attorney and a defense attorney. The jail is disgusting. If you go in there, people were sleeping in pods. The conditions should not be that way. You have one man manning 50 and 60 inmates. That cannot happen and people be safe. And so at some point, we have to put blame where blame lies. And where it lies is with Chairman Rob Pitts and those 6 commissioners that sit with him. And they have a duty that in 2 weeks, they need to issue a budget for our sheriff and for this district attorney's office that does the job.
And she walked off after that. So that's the crazy part about this, guys. That was midweek. Now, last night, this article came out. Are y'all ready? This is really where the tea lies. Fani Willis threatens to sue Fulton County commissioners over the budget. So you just saw that speech. Here is why it was made, okay? Hear me clearly. If you enact the proposed budget, people will die, she wrote in a letter to the board last month. Fulton County District Attorney Fani Willis issued a 7-page letter to the Fulton County Board of Commissioners last month threatening to sue if her office is not sufficiently funded in 2025. So we just saw that speech. We all saw the same thing. You're blaming the prison systems and all of that stuff, right? Okay, great. Let's keep reading. Through an open records request, Capital B Atlanta obtained documents Willis's office sent to the Board of Commissioners on December 11th in response to the county's proposed budget, which the district attorney insisted does not adequately support the needs of her office and thus would endanger citizens and worsen conditions at the Fulton County Jail. Fulton County's Board of Commissioners are expected to finalize this year's budget at their next meeting on January 22nd, sometime next week, determining how the county will allocate $990 million in a general fund. Willis and other justice officials have been sounding the alarm about departmental underfunding for months, cautioning of potential setbacks in managing the jail population, keeping courts operating efficiently, and preventing crime and violence. She says, without adequate funding to properly serve the citizens in this county, we have to explore legal remedies, which includes filing a lawsuit against the Board of Commissioners to seek a budget consistent with the number and nature of cases this office handles. The district attorney's office did not respond to requests for comment. As of January 8th commissioners meeting, the district attorney's office will be allocated $39 million for 2025. Ani is saying that that's not enough. So if there is funding for the state and for Fulton County, if they have $990 million and this governmental body has to allocate that money to multiple departments, she's saying that the $39 million is not enough for her and her office. Willis requests an unspecified funding increase that is sufficient to restore the 20% staff reduction she says she was forced to make last year. Those personnel cuts were caused by the December 31st ending of a federally funded program called Project Orca, which was created to address deadly overcrowding in Fulton County Jail. An accumulation of cases in the Fulton County court system, due in large to part COVID-19 pandemic-related court shutdowns. Project Orca, and remember guys, it's a federally funded program which just ended. It launched in December of 2021, just 1 year into Willis's first term as district attorney. The program allowed Fulton County to hire 528 employees, including 133 in the district attorney's office, to resolve 48,000 backed up cases that dated back to at least 2015. The initiative was widely deemed a success, helping to bring Fulton County's jails population from over 2,600 people in December of 2021 to 1,600 in the second week of December of 2024. So they've decreased the population more than 500 people below capacity, according to the Fulton County data. As those issues began to ease, Orca funding and personnel dwindled. By October of 2024, just before the project came to an end, the district attorney's office had retained 55 Orca hires as full-time employees. Willis says the budget initially proposed in November is likely to undo the progress her office has made. If the proposed budget is enacted, Fulton County will certainly see a dramatic increase in its jail population, and it is likely to lose much of the progress that has been made in reducing violent crime. Willis wrote, also projecting that the Fulton County jail population would increase by at least 1,000 detainees by this year's end, bringing the head count well beyond the facility's maximum capacity. Hear me clearly, she says. If you enact the proposed budget, people will die, Willis wrote in bold type. Elsewhere in the letter, Willis described the inhumane conditions of the Fulton County Jail, blaming the commissioners for failing to provide more funding for her office and the sheriff. The U.S. Department of Justice and Fulton County entered into a consent decree earlier this month, whereby the county agrees to address the deplorable jail conditions to avoid a potential lawsuit. Dozens of detainees have died at the facility in recent years. So there's a consent decree, right? But remember, the U.S. Department of Justice had been doing some research. They released a report in October, and they did their own research to see what the conditions of the jail are like. They conducted their own study. And it took them a while to put together. I read it. It's very long. It's a very long document. I think it's like between 80 and 100 pages. But they came up with all of these reasons to show that the state of that prison is now becoming, it's teetering the line. It's not even teetering. It's over the line of human rights violations. It does. But you see people playing the blame game instead of actually fixing it. Anywho, Willis also noted that homicides, rapes, and aggravated assaults dropped in Atlanta by greater margins than the national average, citing FBI data. She attributed these improvements in crime reduction to her office having adequate resources to investigate and indict as quickly as possible. Fulton County declined to comment on pending litigation. Rob Pitts, chairman of the Fulton County Board of Commissioners, told Capital B Atlanta in October that there would be financial constraints on the 2025 budget due to the board not increasing the county's property taxes. The revenue which we will have to work with will be fixed, said Pitts. All of the programs and projects will have to be funded with the available revenue. Chief Magistrate Judge Cassandra Kirk and Sheriff Pat Labatt have repeatedly asked the Board of Commissioners for more funds. The courts are allocated $5 million in the proposed 2025 budget, while the sheriff's office is slated to receive $151 million. 10 ORCA magistrate staff left in August of 2024, and we continue to request sustainable funding to continue the great work we have been proven to do, Kirk said during the January 8th board meeting. ORCA was a Band-Aid, and we knew it, she continued, but ORCA allowed us to show this court what this court could achieve if adequately resourced. Attached to Willis's letter are annual findings from 4 grand juries convened to inspect the Fulton County Jail each year between 2021 and 2024. The first 3 grand juries recommend the Board of Commissioners consider approving the construction of a new jail. The 4th attached a copy of the jail feasibility study commissioned by the county. The grand jury findings, which were shared with the commissioners at the same time, are likely to play a role in the lawsuit, should Willis decide to sue. Earlier this week, Republicans in the state House voted to revive a special committee to investigate alleged misconduct by Willis's office. She has faced criticism for dedicating her office resources to high-profile racketeering cases against Atlanta rapper Young Thug and former President Donald Trump, while the Fulton County case backlog was still massive. That's the thing. You're asking for money, but at the same time, is the strategic approach that the office is taking, is it actually helping people? If there is this backlog of cases, if people are trying to get justice for crimes that happened to them a long time ago, since 2015, why are we pursuing Young Thug and Trump? Granted, you guys know in the YSL case, 28 defendants, all of those should have been tried separately, all of them. And then with the Trump thing, Fani she is one of the only people that got a presidential mugshot, right? We don't have a conviction, but you have a presidential mugshot. All the other cases he was involved in, we don't have that. And shout out to the Cash App crew. I do see you guys here in the chat. Just glance over on this side. I will read those out in a second. If you guys want to support the show, all the ways to do that are here in the banner. Of course, it means so much. But when I start cooking, I start cooking. But guys, look, this is interesting. So you're asking for the funding, but you're also focusing on RICO cases instead of focusing on that backlog. The special committee, however, is primarily concerned with the romantic relationship between Willis and Wade, the special prosecutor she hired for the Trump case. The Georgia Court of Appeals ruled last month that she be removed from the case due to the previously undisclosed relationship. She appealed that decision to the Georgia Supreme Court earlier this month. AKA Monday. This is the letter that she wrote to the commissioners where she threatens to sue them. It's about 7 pages. I don't even know where to start with this, but this is a letter. Y'all want to read it? Put a Y in the chat if you want me to read the letter where she threatened to sue these people. There it is. There's her signature. Let me know what y'all think. Dear Will Christian says, yes, good to see you, brother. CAG's like, no, let's read the letter. Rockin' Robin says no. Okay, let me finish the article and then we'll go to the letter. But yeah, her letters are interesting though. They are very threatening. Let's keep going. Oh, this looks like a grand jury findings. Interesting. Wow, guys. Okay. Dang, this is very long. These look like other exhibits. Let me scroll down. Oh, no, that's the end of the article. That's the end of the article, but we just have the letter to the Fulton County Board of Commissioners. Guys, guess how I found out about this article? Through Ashley Merchant. Ashley tweeted about it yesterday. And she said, perhaps Fani Willis should have been more careful with the taxpayer funds given to her office in the past. Or maybe she should have permitted the audit of her office. Or maybe not told the Fulton County Board of Commissioners that they gave her a budget and she could spend it however she sees fit. Interesting, guys. But let's look at the threatening letter. Let's look at the threatening letter. Where's her threats to these people that she wrote last month? She was busy. Here it is. We'll just read the first 7 pages. I'm going to skim. Okay, she sends it to the Board of Commissioners and Chairman Rob Pitts and Commissioners. I write to you to bring to your attention to a crisis that each of you is aware, and the actions of the Board of Commissioners is responsible for it, and you are the only people empowered in Fulton County government to address it. Specifically, Fulton County's proposed budget for 2025 calendar year, if enacted in any form close to the current proposal, will greatly undermine ongoing efforts to move cases forward in a timely manner. Broadly, the board's budgetary neglect of my office will result in a less safe community for Fulton County citizens and a worsening of a crisis at the Fulton County Jail that you have long neglected. The proposed budget, if enacted, will lead to needless deaths here in the county. We are all elected to serve. During the budget process, my staff provided you with detailed information about our office, and it needs to ensure that we can ensure the progress made over the last 4 years is not lost and that we can continue to make progress as we move forward. Which, now that we know the truth, guys, the urgency behind this letter, and it's dated December 11th, the urgency behind this letter is that she's losing that federal funding. Do y'all remember all of those times Jim Jordan and all these like US congressional members were asking for her to comply with subpoenas, and she was just blatantly ignoring them? The federal government wanted to know, they wanted to inquire on the funding that they had given her in the past and how it was used. I think it was last spring, there was a young woman who was a whistleblower who mentioned that that money was not being spent properly, that it was being purchased, they were buying swag. Like, we call that merch as YouTubers, but they were buying district attorney merch. Were they actually using that federal funding to make change in the community? Fani says yes. But she knew, that's why she wrote this letter, that federal funding was running out. So if you're not complying with the federal government, can they take the funding away? And is that the rationale behind it? Who knows? It is on the conspiracy tinfoil hat side of the house, but it is interesting. Let's keep going. And sorry, guys, this is a little bit small. I don't know if it fits, if it all fits. Does it fit? Let's see, does it fit? It fits. And as I have discussed with each of you, our case intake division has made great progress in reducing Fulton County's number of unindicted cases. We've seen a dramatic drop in crime. At the same time, we've seen a dramatic decrease in the number of defendants held in the Fulton County Jail, awaiting adjudication for their cases. When I took office, there were over 3,700 inmates in the jail, in excess of 600 sleeping on the floor at a given time. In 2024, the number of inmates in the jail declined as low as 2,300 people. Despite the personnel cuts this office has endured this year, we have been able to keep the jail population below 2,500 at the end of 2024. The proposed budget, however, will reverse that progress and send the case backlog and jail population sky high again. The proposed budget not only fails to restore any of the almost 20% cut in district attorney personnel that occurred in 2024 and fails to restore a single position this office requested, but it also proposes further cuts due to the plan to block the filing of a vacant existing position for months at a time. Again, if the proposed budget is enacted, Fulton County will certainly see a dramatic increase in its jail population and is likely to lose much of that progress that it has made in reducing violent crime. If the proposed budget is enacted with its further cuts in this office, the jail population will be over 3,500 by the end of 2025. She says, hear me clearly. If you enact the proposed budget, people will die. That is such a Fani Willis thing to write. Okay, what's her rationale behind this? She says, as we have dramatically improved our backlog of unindicted cases, improved our investigation before indictment, and our cooperation with our partner law enforcement agencies, violent crime in our community has declined dramatically. In our case intake division's progress in the inherited backlog and improved pre-indictment process, my administration inherited 18,000 unindicted cases, the oldest dating back to 2014. That situation was certainly mistreatment of victims and also suspects who had to wait years to learn whether charges would be brought against them. We have fully overhauled the indictment process by gathering evidence before indictment. This not only allows for the best charging decisions, but provides for faster case resolution. Now, you know what I just thought about reading that? YSL case, right? 28 defendants total. Reduced it down. People took plea deals. You guys remember we watched the very last plea deal day where, Judge Whitaker is really trying to get some of these defendants off. Was it Miles Farley? Defendant Farley. That was a college student, which all he did, the only charge he had against him was conspiracy for RICO. It was count 1. Why? Because he made merch that said, "Make America slime again." That's what he went to jail for. So 18,000 cases. And we're charging people like that. I don't know. I don't know. What do y'all think about that? I mean, why are we charging people of crimes that are allegedly RICO because they made merch? Like, what? What is that? We have I think I read that part. We have fully overhauled the indictment process by gathering evidence. This not only allows for the best charging decisions, but provides for faster case resolution. Our intake division now works with police departments to fully investigate cases and secure necessary evidence before we indict. The complaint room that the case intake division replaced quickly would indict suspects based on nothing more than a fact statement from a police officer with no effort to secure critical evidence such as a security camera video, witness statements, or results from crime lab tests. All too often, indictments would be dismissed because the complaint room system resulted in indictments that charge people with crimes that could not be proven. Are you kidding me? Y'all are charging people without evidence? Oh my God. Like, what? The case intake division has allowed us to reduce the number of unindicted cases in this office by more than 5, which ensures that we conduct investigations and secure evidence before bringing indictments. Good. or felony accusations against those persons accused. This greatly improved process ensures that our courts no longer have to engage in a mass dismissal of cases for lack of evidence, that victims do not see justice denied due to a failure to build proper cases against defendants, and that people do not unjustifiably face felony indictment for cases in which sufficient evidence to prove the charges has not been secured. Well, I mean, I'm glad that she did this, at least, but at the same time, why is it that easy? This is not funny at all. You guys are charging people for crimes without evidence. That means somebody can say, hey, AV ran me over. You're going to arrest me? You're going to charge me for that? What? With no evidence? Oh my God. Shout out to Full Drinking and Half Thinking. I'll read that in a second. Good to see you, brother. We will not be returning to the complaint room model. Doing so would be a violation of oaths I took as a constitutional officer and as an attorney. It is unethical for a prosecutor to indict or accuse someone of a felony without evidence in hand that the prosecutor reasonably believes will prove the person's guilt beyond a reasonable doubt at trial. What about Trump? What about Thug? What about Farley with his merch? Too many people were indicted by the previous administration of this office, despite the office lacking the necessary evidence. And then were put into a position of being pressured to plead guilty to those same charges. Further, victims were poorly served by a system that saw too many cases dismissed simply because the district attorney's office failed to secure evidence that later disappeared. What? Such as surveillance video, witness testimony. This office cannot, and as long as I am district attorney, will not return to the system that puts speed of indictment ahead of the investigatory process, who are obligated to pursue and ensure that the evidence exists to justify charges that are brought. And that really is what law enforcement should be helping them out with. For optimal efficiency, the case intake division takes 47 lawyers, 20 investigators, 10 support professionals to adequately operate the unit. This team works 52 weeks out of a year, including weekends. The case intake division handles 98% of accusations, indictments, and diversion referrals. In addition to handling 98% of the charging decisions, the case intake division handles the following court proceedings: grand jury, first appearance, prelim hearings, bond hearings, and non-complex court 1 and non-complex court 2. These court proceedings require lawyers to be present and prepaid in excess of 30 times per week in order to handle hundreds of defendants. Because Superior Court judges have been given 43% of their caseload to non-elected county-funded judges, the case intake division also prosecutes 43% of all cases assigned to Superior Court judges through non-complex Court 1 and 2. Based on the proposed current budget cuts, the case intake will be forced to operate with only 14 lawyers in 2025, and the jail population will soar in 2025. All right. New programs that make Fulton County a safer, more just place for everyone have been created and are working. In October, we created the Fulton County first ever pre-indictment diversion program, which is taking hundreds of cases out of our judicial system. More importantly, the program has allowed us to resolve cases with the program that has defendants pay restitution, pay fees, learn life skills, and be more connected to job opportunities. And we do not mark them with a scarlet letter of a felony indictment and all negative life consequences that come from that. To date, 700 people have taken advantage of the program, with 324 successful graduates and 400 actively participating. In our case intake division, we have built specialty units that handle crimes against children, DV, elder abuse, animal cruelty, cold case murders, and cases built on non-neglected grape kits. We have a new repeat offender tracking unit in cooperation with the Atlanta Police Department and Police Foundation. The success of these efforts is reflected in the dramatically improved crime rate in our community. All of these efforts have been combined to lower our crime rate, especially our violent crime rate, dramatically and much more than the national average. In fact, in September, the FBI released its nationwide crime statistics. Blah, I've been reading a lot. The report detailed the dramatic progress we are making in reducing violent crime and doing so at a rate much faster than the national average. In Atlanta, homicides are down 21%, Grapes are down 51%, and aggravated assaults are down 16%. That progress has continued in the calendar year, with another 10% drop in homicides through September of 24, with a decrease in shootings as well. The Midtown Alliance reports that crime in Midtown Atlanta was at a 25-year low. Buckhead Coalition reports that Buckhead in 2023 robberies were down 29%. I don't believe that, because I lived in Buckhead and still got my house robbed. So I don't know. I mean, and that's a 2023 number. What about 24? So anyway, Buckhead also had aggravated assaults reduced by 39%, grapes down by 60%, auto thefts 13%, and auto thefts were down 11%. I remember last year there was a parking deck in Atlanta. I think it was in Buckhead. And like, it was like a group of hooligans. There were some young kids that like just grabbed some bricks and they busted everybody's car window open. It was like 200 cars. So where's the 2024 numbers? I want to know that, because I know that that just happened. Interesting. The county's administration proposed budget threatens to reverse recent progress, increase violent crime, and swell the jail population, ultimately putting lives at risk. She talked about that already, so I'm going to skip it. The commissioner is on notice on each of these last 4 years about the deplorable conditions at the jail and refused to act. You are now on notice that your continued refusal to adequately staff this office will worsen the conditions there and make Fulton County less safe. So she is now saying that if y'all don't help me, you're going to make it like worse for the jail. Interesting. She's also now put on notice again via this letter that the budget for this office will prevent me from fulfilling my duties as DA and will make Fulton County less safe and worsen the already deplorable unconstitutional conditions at the jail. I want to find where she actually threatens to sue them. Each of you are on notice. The budget is inadequate to allow this office to fulfill its legal obligations to the citizens of Fulton County. Should you enact it without the necessary resources for my office, you'll be voting to endanger citizens and worsen the conditions at the jail. In any sense you may have that you are saving money through the proposed cuts is wrong-headed. As stated above, the increased jail population will cost millions of dollars in judgments because you will willfully have failed to fund public safety. The county commissioners have placed this office in an untenable position, forcing me to make a decision on division of resources. Let me be clear. All of the hard work we have done to reduce the backlog, decrease jail numbers, and bring efficiency to the criminal justice system will be lost because of underfunding. Without adequate funding to properly serve the citizens of this county, we have to explore legal remedies, which includes filing a lawsuit against the Board of Commissioners to seek a budget consistent with the number and nature of that the case is handled. So that's where she says it. Give me my money or I'm gonna sue you. Like, oh God, dear Lord, that's crazy. There is a legal and factual conflict of interest for the county attorney to revise counsel represent the DA's office regarding this matter. Notably, Rule 1.7 of the Georgia Rules of Professional Conduct prohibits County Attorney Joe from representing my office, and such conflict cannot be waived. As such, we request that this board to authorize and fund individual legal counsel to represent the needs of this office. Wow. Well, there you have it, ladies and gentlemen. Fani Willis has been all over the place. Monday, it starts with asking the Supreme Court to put her back on the Trump case. And I wonder, the federal funding's about to run out. So she sends this letter and threatens to sue the people that are making the budget cuts, even though they're giving the jail the most amount of money. It's $990 million, I believe. I think they're giving the jail $151 million. So they're giving a big bulk of it to the jail because the jail needs help. You saw that clip I just showed you. She was saying that it's their fault. I was wondering why she was like coming down hard at these commissioners and stuff. They're getting their funding, but it's because the federal funding is running out. Do you guys think this is conspiracy time? And again, it's not legal. We don't have any facts to support this. Federal funding is running out, but does that indicate that it's not being renewed? How does that impact things? I mean, I don't know. This whole thing is just wild to me. Anyway, that is my complete Power Hour update on all things regarding the Fani Willis Trump situation. We looked at Trump's petition to keep her off of the case. We'll see ultimately what the Supreme Court does. We're going to have a decision on that soon. We have the Drake lawsuit. I was editing that last night. I still need to finish it. So hopefully we get that out to you guys tonight. We're filming tomorrow on the Karen Reed case. We're getting out in the field where the work is real. We're getting ready for the Karen Reed case, and we are going to be filming a documentary tomorrow. It's episode 2, so really excited about that. And then what else do we have cooking? I think that's all we have for content this weekend, but we will be getting that out to y'all. Anywho, let's come to our super chats and see where we are. Shout out to There Goes Stacy, and I think you just left us a super thanks too. So thank you so much, Stacy. E. Capone, we caught that one. Felon should not be president. We caught that. E. Capone hits me with another 5 and says, orcas are mammals. Are they? They are. They are. But I think that program was called Orca too. So thank you so much, E. Capone. Shout out to Penny G. Haven't seen you in a while with the 10. Penny says a serious DOJ corruption case should be open. Yeah. Threatening to sue your, people that you work with in the government because you're losing your federal funding. But the federal funding was actually what was paying a lot of those resources. And now she's like, okay, I'm going to have to make more cuts. And she's explaining what happens if she makes those cuts. It's funny, though, because some of that money is going to Nathan, no? I think so. I think it was. Thank you so much, Penny G. Shout out to Full Drink and a Half Thinking with the 20 says, happy Friday. Enjoy the weekend. Be smart. Be safe. AV, get it, mama. That's right. Thank you so much, Full Drink and Half Thinking. Content creators. Any of the mods are around, drop the link to their chat. You guys check them out. Great podcast over there. Coming to some of you guys on the Cash App side. Thank you so much, everybody, for supporting the show. Cash Apps are always amazing because that gets to us right away. Shout out to E. Capone, who hits me on the Cash App side as well. Sends me $5, says, Fika Nasima, AV. I think he's telling me to stay up here. I do need to go to Atlanta soon. I might actually be down there on the 7th where this next YSL hearing is going to happen. So maybe I'll pop in. Shout out to IJG. Thank you so much with the 5. Says, for being beautiful and an amazing person. Thank you so much. Really appreciate that. We try to work hard over here and we're really excited for this year. We've got a lot of good stuff coming for you guys. Some of you guys are asking if we're going to cover the inauguration. I'm not quite sure yet. It depends on what our content backlog looks like. And it also depends on our filming tomorrow. But that's one of my New Year's goals is I'm going to be actually going to crime scenes, actually getting out in the field, talking to people, getting from out of this office and doing something different with the content. So we're really excited. So when y'all support the channel, whether it is liking, commenting, leaving a super chat, sending a Cash App, you're helping fund all of the things that we need to do to make these projects get off the ground. I mean, all of it. Like, we need lenses, we need cameras, we need all these pieces of equipment. Like, you guys always help us improve when you support what we're doing. So I really want to thank y'all for that. Seriously, we're off to a really good start this year and we're going from there. A lot of you guys are asking about Tiffany Hanyard. Yeah, this year is crazy, like with everything that we have going on. We've got Karen Reed, we've got this YSL case, we've got the Diddy case that we're trying to stay on top of. Then we're trying to keep up with the news because lawsuits drop every single day. The Keefe D case, I believe, is in March. We're going to Vegas for that one. Definitely going to New York for Diddy. We'll be seeing a lot of the LawTube friends. I think Donna Adelson is in Florida, so we got to plan all of that out. Melly is in Florida as well, so definitely got to plan all that out. There's a lot going on. Aja, thank you so much for asking about Turtle Boy. I hit him up on Twitter. I don't know what the best way to get in touch with Turtle Boy is, but I will try to follow up with email. And then I'm also trying to work on another thing with this. Is it Joy? What is the woman named Joy that's like doing all types of freak off stuff at Fox News? I have some friends that are former NFL players. So I'm trying to work on an interview with somebody that's kind of close to the situation. So it's always busy in the AV world. Always, always, always busy. Anywho, someone else got indicted. Shang Tao, former mayor of Oakland, has been indicted by the feds today. Oh my God. Crazy. See, do you see what I mean about legal news? Today, I woke up to the YSL thing. We were working on this, and then, TikTok got banned. There's like 4 or 5 stories. It's never a dull day. Joy Taylor, thank you. Thank you, thank you. Yeah, guys, we're all over the place. Shout out to Dear Woke Christian. Thank you so much for watching, brother. And I've been checking out your channel. Guys, if you are free, check out Dear Woke Christian's channel. He has been a member on my channel for 7 months. 7, lucky 7. Says, great work, AV. Glad to support one of the best. Right back at you, Jason. Thank you so much for all you do for me and in the community. He is one of the creators that were really like covering all things Atlanta, all things YSL. Great content creator. Please check him out if you haven't already. Yeah, guys, the whole Joy Taylor thing, that's going to be a good interview if I can make it happen. But I'll actually have to just reminded me to make a note to follow up with that person. All right, folks, I'm going to get some lunch. Thank you so much for supporting the channel. We've got a lot of great things going on. At the end of every episode, I'll try to keep you informed on the progress and things, but stay safe out there. I will see you in the next one. Bye.